Now we talked about home inspection agreement and why it's important. Let me talk about one specific area in a home inspection agreement where it can be confusing for the home inspector, and therefore it's obviously going to have a chance of being confusing for the client, and that is limitation of liability clauses. Somewhere along the line, somebody got the idea that if you claim that your liability is limited to your home inspection fee, then no matter how bad the job that you do is, you're never going to have to do anything other than give your $400 or $500 inspection fee back. That is not true. Let me repeat that. That is not true. I don't know where that idea came from, but there is something in the law that's called fundamental fairness. So if you collect $400 from somebody, but you miss an item that costs $50,000 to repair, you are not going to get away by just handing them their $400 back and having them sign a release and have everybody happy. You're going to get a claim, and you're probably going to get sued. So why am I saying that limitation of liability clause is not effective? Because there are ways to make it effective. Number one, you have to have a meaningful dollar amount if you are going to try to limit liability to a specific monetary number. It can't simply be automatically be your inspection fee. Maybe it could be 2 times your inspection fee, 3 times, maybe a fixed dollar amount, $1,000, $2,500. In that case, I'd suggest maybe that number match your deductible because you're going to have to pay that anyway. And trust me, it's worth paying that amount to avoid having a claim if you can. But there are also states that have statutory or legal decisions that affect your ability to claim a limit on your liability in the event that you do make a mistake. And people make mistakes. This is not about anything intentional or unintentional. This is about you're in a profession. It's a complicated job. Not every house is the same, and there are going to be times when you don't see something that you should have, or where you see something incorrectly, and that's fine. That's why you have insurance, and that's why you have a home inspection agreement. But in terms of limiting liability, in the state of New Jersey, for example, there was a movement afoot to have home inspectors limit their liability to their home inspection fee. Unfortunately, there's a statute in New Jersey that says if you're a home inspector, you have to carry $1 million liability insurance. So when the case got to court and the challenge was, is the liability limited to the home inspection fee or not, the court's reasoning was, well, if the legislature said you have to carry $1 million of insurance, that whole $1 million of insurance has to be available for your clients to use. Otherwise, it's the statute that was passed by the legislature is pointless. So no, you can't limit your liability. Your limitation of liability is the face value of your insurance policy. That decision was probably a dozen years ago or more. My feeling is that there have probably been many states since then that have looked at the same question and may have resolved it the same way. So you probably need to have local legal counsel take a look at a limitation of liability clause and do a little research both into state statutes and regulations and into state court decisions to find out if the form agreement you're using, whether it's come from a franchisor, a state association, or even an insurance company that sends out form agreements sometimes for people to use as examples, you want to make sure that in the state you're in, that particular clause is properly drafted, because having that clause can indeed help you. But having a clause that's not legal in the state you're in can hurt you also. So you want to spend time on that. You also want to put a time limit. You don't want the client to have 10 years to call you back. I can barely remember what I did yesterday. Maybe with a written report in hand, I might be able to remember what I did last year, but that's about it. So I think one of the things you also want to do in terms of limiting your liability from an amount is also limit your liability exposure from a time standpoint. Some states have statute of limitations that would apply. Some don't. The interesting thing about a statute of limitations in a civil sense is that you can, by contract, agree to a shorter or longer period of time, and it will be enforced. So contractually, even if the state says there's a 3-year statute of limitations to file claims for breach of contract, you could put in your home inspection agreement, which is a contract, a clause that says that any problems that result have to be reported within 1 year to you. And they have to give you an opportunity to re-inspect and see the problem, document the re-inspection so there's a comparison between what you saw when you were there the first time and the second time. And you want to be able to do that before the homeowner hires a contractor who starts ripping everything out, because then you never get to see what the homeowner saw when they called you and said there was a problem. So limiting the time for a claim and making sure that you have the opportunity to go back in and re-inspect and possibly cure the problem. Once again, using your monetary limit of liability, you may very well be able to sit down with the homeowner, your client who now owns the home, look at what the problem is and say, you know what, it's a close call. I'll give you $200 to fix it. Here's the money, here's a release, and we're done. That's less than your deductible. You've done your job as a professional. And to avoid claims, you do want to make sure that when you get a call from a former client, you return the call right away. Because generally speaking, the public believes that if they reach out to ask you a question or to report a problem and you don't call them back, you're ducking them, which then in their mind means you're guilty. You did something, you're now trying to hide it. So when you get those calls from former clients, call them back right away. Make time to get out there and take a look at it right away. And roll that into your limitation of liability thinking process. Is I want to limit the dollar amount, I want to limit the time, I want to make sure that I'm notified, and I want to make sure that I make time right away to go back out and look at it, so that all of this stuff is captured and recorded and documented as much as possible. Then even if you can't find a way to settle it, you're going to be in a much better shape if a claim does come, and especially if you end up in court. I think there's another big issue about home inspection reports, and that is, okay, so Mr. Smith comes to me and says, I'm buying 123 Main Street. I want you to do a home inspection. I go out and inspect 123 Main Street, and I say, yeah, everything looks fine. Mr. Smith, I don't see any major problems. There's some staining on the concrete on the basement floor, but it looks like it's been there for a long time. No evidence of roof leaks. Right. But then Smith's bank says, sorry, you don't qualify for a loan. So Smith walks away from that property. Most real estate purchase contracts will require Mr. Smith to give the current owner of 123 Main Street a copy of the home inspection report. It says, if for any reason you don't buy the house, you have to give us, the seller, a copy of all your agreements. So you give them a copy of the home inspection report. They tear the cover page off that says this report was prepared for Mr. Smith and is covering 123 Main Street. They make copies, they set it on the counter for the next open house. Next buyer comes in, picks up a copy, says, oh, look, the house was inspected 30 days ago. I don't need to order one. Then they close 90 days later, or now these days, 9 days later. And then next thing you know, you get a phone call from somebody you've never heard of, asking you questions about home inspection you wrote on 123 Main Street for an entirely different client. Now, admittedly, there are a lot of people that did things wrong, including the buyer who picked up a report that wasn't done for them and relied on it. But the bottom line is you need to protect yourself from that happening. And one of the best ways is to put in your inspection report on multiple pages. This report can be used by and relied on only by the client, Mr. Smith, who hired and paid you. Anybody else who picks this report up and relies on it does so at their own risk. And my insurance does not cover them if they have a problem later. Put that language in your report. Put it in your agreement too. Make it clear. Because keep in mind, it is in your agreement, but you don't give a copy of your signed agreement to the seller. They only get a copy of the report. So if you don't repeat it in your report, your agreement with Mr. Smith that he's the only one who can use your report won't impact Mr. Jones, who picked up the copy at the open house and decided he was going to rely on it. Your report has to say, Mr. Smith's report, only Mr. Smith, not you, Mr. Jones, only Mr. Smith. And that's really important in terms of limiting your liability. Kelly, you have anything to offer on that? I know we've both seen a number of those situations.
Yeah, we've seen many claims come in where it's not the person that the inspector did the inspection for. It could be completely somebody else. Like you said, the buyer doesn't buy the property, and that inspection report shouldn't be relied on by anybody else. But we see claims come in all the time.
Yeah, we've also seen judges who rule in favor of Mr. Jones and say, sorry, inspector, your report was lying there. It's not his fault that he picked it up and relied on it. He's a consumer, you're a professional. And there's the problem is the court system views home inspectors as professionals, no different than doctors. You're supposed to know more about what you're doing than your clients are because they're just poor consumers. As we mentioned before, they don't do this every day. They do this maybe once every 10 years. You do it every day. So the court's assumption is if there's any ambiguity, any confusion, anything that's not perfectly obvious, it's your fault because you're the professional, no matter what the consumer did. And I think we've seen court decisions on this particular issue about using an inspection report that was actually written for somebody else. Judges have said, sorry, if they picked it up, they should be able to rely on it too. Now, I think that's a bad decision, but insurance companies aren't going to spend hundreds of thousands of dollars trying to craft a new legal decision at the state Supreme Court in order to avoid paying a $5,000 claim. Their business is too, and that's the way they approach it. They're not going to litigate that issue the way you'd want to. They'll litigate it so that it makes sense for them from an economic standpoint. If you're going to try to limit your liability, those are areas you really need to be careful about what you're doing. You want to make sure you limit the monetary amount, the time for reporting a claim. You want to make sure you have an opportunity to re-inspect before any work is done to repair any problems. And then you also want to make sure that the report itself is clearly states that it can only be used by your client. Nobody else can rely on it. And if they do, there's no insurance coverage for them. Thank you.
Thank you.